We can start.
Okay, wonderful. Good evening and welcome to all of you. It's very nice to meet you all so soon after the Labor Day. Uh, During Labor Day, I'm sure the importance of industrial relations became known to most of us who might have probably not been very aware of it. But it is in a very curious context that we're holding today's lecture. Because on the one hand, you're facing a time when more and more uh, the employment relationship has been individualized, and that's one thing that the labor movement in India and across the world has been consistently pushing back against. Because when employment relationships are negotiated between the employer and the worker on a one-on-one basis, there is that basic acknowledgement of the inequality of the worker and the employer, which is the very basis of the push for collectivization, collective negotiation of employment relations. In India, there have been a series of very curious, very strange labor reforms that have left us in a state of a little bit of confusion, a little bit of outrage, a little bit of perhaps joy. As you will all remember, between 2019, 2020, and now, uh, four major central laws have been passed by the Indian Parliament that rewrite labor law as we know it to a very large extent. During COVID and quite recently in the states of Karnataka, Tamil Nadu, perhaps soon also in the state of Uttar Pradesh, there have been very strong attempts at increasing the length of the working day and leading to further extraction of work from a vulnerable workforce in this push for greater industrialization. Even though the laws for labor reforms were passed at the central level about 2.5 years ago, there have been no significant movements towards the implementation of those laws. So there is still this state of policy paralysis, confusion, even among members of the labor departments of various states, among labor activists. And it is in this context that we are today talking about industrial relations. I will not spend very long introducing Professor Babu Mathew, who most of us know, most of us admire. Some of us, including me, have been very lucky to learn from and work with. I could spend the rest of this lecture talking about his extensive work in industrial relations or a 4-decade-long teaching career. For now, I will just leave it at this by saying that he has experience of working with a very diverse, a very vast group of different kinds of workers, collectivizations, and trade unions, whether in small manufacturing, large manufacturing, in PSUs, in the restaurant sector. Many informal workers' unions have been fortunate to have him as a consistent friend and supporter, including unions for domestic workers, sex workers, fisher folk, building and construction workers, most recently also platform workers. Professor Babu is an activist researcher and has dedicated many years of his life to working on legal reform, assisting both people's movements and governments in trying to formulate laws that are more reflective of the reality of labor law implementation. He has an extensive history of work on, say, the Karnataka Industrial Disputes Act amendment. He's done a lot of pre-legislative research on laws for slum dwellers, for Devdasis. He's also authored a report for the government of Karnataka on the state of platform work in the state. Also has an extensive history of activism in human rights, including for people in conditions of forced labor and bondage. I will hand over now to Professor Babu, and I really look forward to listening to you.
Thank you, Kavya. It's an unexpected pleasure that you are chairing this session. I must thank Working People's Coalition for the same. I'm very happy that this very organized initiative from WPC, with the help of Neena Menon, Chinmay, and so many other friends, is being done in this manner. I'm aware that we are going into a series of lectures and that it seeks to address labor activists across the country. On this occasion, I have no claim to be exhaustive in relation to the subject matter that I am going to talk on, namely the Industrial Relations Code of 2020. It's because, for purposes of labor activism of the proper type, one lecture is far from enough, and we'll have to actually learn labor law by using different methods, above all by concretely defending the workers, and where possible by engaging in collective bargaining. And closely associated, of course, is the challenge of mobilizing people in support of what we want. And that mobilization often leads to confrontation, and the importance of advocacy and the use of all available legitimate means, including law. And I must say, in the Indian context, labor law has been of great value for all those who did serious trade union work. It's not only because the statutory framework was reasonably good, but also because of the manner in which labor jurisprudence evolved in the country. And when we talk of how labor jurisprudence evolved, we must remember the role of the judiciary. And by judiciary in this context, I mean starting from the labor court or the industrial tribunal, as the case may have been, passing through the high court from a single bench to a division bench, and then approaching the Supreme Court. In the earlier days, there was also the Labor Appellate Tribunal. And so that's a journey through which jurisprudence was developed. One realization from my long experience with this process is it's impossible to develop labor jurisprudence through this last route without a very committed trade union. An individual worker can never do that, because very often it takes decades to push the process from the base unit of legal litigation to the apex unit of trying to get a judgment. So that's a very long journey. Fortunately, in India, for a long period of time, we had labor lawyers with commitment, so much commitment that they would never take up a case for the management or for any other cause. They were dedicated to the cause of the workers, and very often, most often, they did pro bono work. And we had the privilege of such friends in the trade union movement, from the base unit through the High Court to the Supreme Court. Otherwise, many of these cases which helped workers would never have emerged. So when we are talking of the Industrial Relations Code today, then we must remember that this Industrial Relations Code is trying to address that long history of jurisprudence. It may not be wrong to say that India's labor law jurisprudence is certainly of very high quality. There may be very few countries in the world that have evolved it in this manner. It's wrongly presumed that it took up the cause only of workers. I wouldn't accept that formulation, for the reason that immediately after independence, there were many stalwarts who, in the ruling party, helped the cause of the workers. And that was a philosophical commitment. I think the Industrial Truce Resolution of India, as early as 1947, was moved and adopted by the employers and the trade unions. And what was that truce resolution? It said that, workers must not go on strike, since we've got independence and must get into development, and employers must engage in fair labor practices. So please see the coherence of that approach. I'm of the view that there's tremendous coherence between industrial policy pronouncements and labor policy evolution. they go hand in hand. It's something worth doing for a PhD research scholar to see how these two matched with each other. And so it is part of a national development strategy. Wrongly, contemporary people are under the impression that it is some kind of a deviation from what the nation needs. So I think this is an aspect which one must keep in mind. As Kavya was pointing out, the Industrial Relations Code went through all the legal processes necessary through the Lok Sabha, through the Rajya Sabha. President gave his assent on 28th of September 2020. But then, while all that is on record, we must take note of the fact that there was a deficit in respect of adequate pre-legislative process. This is sadly in violation of the ILO's Convention number 144, which India has ratified. That's a convention which deals with tripartitism. And to bring in such a massive labor law reform, that means all the 4 codes I am now referring to, replacing 29 pieces of labor legislation. Such a massive exercise has never happened in the history of India before. And when you carry out such a massive exercise, how can you ever do it without convening the Indian Labour Conference? It's not as if India is unfamiliar with the Indian Labour Conference. Dr. Ambedkar put it in place as early as 1942. And so we have a long history of the Indian Labour Conference. And it used to be fairly regularly held. The Prime Minister would often attend that conference, the Labour Minister, of course, and all important people, both from management side and trade union side. And there have been so many unanimous resolutions of the Indian Labour Conference, which has led to the creation of labour jurisprudence. So I ask, how can we have decided to produce 4 new labour codes without consulting this Indian Labour Conference? That's a sad reality. And however, it must be noted, otherwise I would be not telling you the entire facts, that there was a standing committee on labor. The Standing Committee on Labor was consulted on the Indian Industrial Relations Code also. But if you read through the proceedings of that, one finds that the government had made up its mind so tightly that they rarely accepted any recommendation of the Standing Committee. So it seems to have been more of, performing a formal process through the Standing Committee. In any case, that's not to be treated as a substitute for tripartitism. The 4 are different. This is part of a parliamentary committee in which the ruling party always has the last word. And so that limitation must be noted. Anyway, perhaps it is a combination of all these reasons which are responsible for the fact that the 4 labor codes have not yet been brought into force. That shows the Achilles heel. If it was a result of positive national consultation, by now, whatever reforms were accepted by all would have perhaps been brought into force. So with that, as an important prelude to what I'm going to say, I begin an analysis of the IR code. And let's remember that it brings together 3 important pieces of legislation. When we talk of the 4 labor codes, loosely in the earlier days, they used to say that it brought together 44 pieces of labor legislation. That is not true. What it brought together was 29 pieces of legislation. However, that apart, so far as the IR code is concerned, it brought together 3 important statutes. One is the Trade Union Act of 1926. The other is the Industrial Employment Standing Orders Act of 1946. And the third is the Industrial Disputes Act of 1947. All these 3 laws occupy a very central place insofar as labor jurisprudence is concerned. But also please note that all these laws are pre-independence. Even the Industrial Disputes Act of 1947 was brought into force on the 1st of April 1947, about 3.5 months before we got independence. I think that itself has a interesting jurisprudence behind it, but I won't go into it for paucity of time. The Trade Union Act was consequent upon a massive struggle carried out by the workers of Buckingham Carnatic Mills in the early 1920s. The employers went to the High Court of Madras and they invoked common law principles because we did not have any statutory law in India on the subject. They followed common law and initiated action in terms of three very old principles. One is that you invoke the civil law in order to get the relief of injunction. The second was they invoked criminal law in order to get the relief of criminal conspiracy. And the third was they resorted to tort law in order to seek compensation for the losses caused on account of the strike. But there was a massive protest against this, not only in India, but in other parts also. And I think the fact that the Labour Party was in power contributed to the relief that came. And the relief was the Trade Union Act of 1926. This act, all it did was it facilitated registration of a trade union, and simultaneously it gave immunity from certain forms of civil action, criminal action, and tort action. So as a result, if you formed a trade union, you could not be accused of the things which Buckingham Carnatic mill workers were accused of. So far as the second piece of legislation, the Industrial Employment Standing Orders Act, it was meant in order to define conditions of employment and to make them known to the workers who were employed. I think it's a combination of these two, which in a sense, if I might borrow an expression from constitutional law, is a door through which the rule of law is introduced into the shop floor. And of course, there were amendments after 1946. The most important amendment was, I think, in 1982, when it was pointed out that the trade unions have a direct role to play. Of course, it is for the employer to draft draft standing orders for his establishment and consult the workers. But after 82 amendment, trade unions had to be consulted, and appropriate government, review of that process would also be, including appeal, would also be through the involvement of trade unions. When this law was enacted, it was meant to cover all establishments with 100 or more workers. Appropriate government, including the state government, could extend it to lesser than 100 workers. I mean, establishments which were less in strength than 100. So all this was, in a sense, in the spirit of the concurrent list. Concurrent list, of course, is a post-constitution development, though it has its own antecedents. This amendment regarding appropriate government's power was introduced in 1961. May I move to the Industrial Disputes Act to make some opening remarks? It was preceded by the Trade Disputes Act of 1929 and also utilized Rule 81A of the Defense of India rules. And it primarily provided for settlement of disputes. In the early days, there were three types of dispute settlement which was known and used. One was conciliation, the other was collective bargaining, and the third was adjudication. If conciliation or collective bargaining failed to provide a result, then it would land up in the courts for adjudication. It's only much later that arbitration was introduced as something in addition to this dispute settlement mechanism. Much later, there was the introduction of provisions in order to regulate job losses on account of layoff, retrenchment, and closure. Chapter 5A was introduced in 53, and Chapter 5B, which went even further, which said that you can't lay off, retrench, or close without taking government's permission. That was in 1976. There was a Supreme Court judgment which first struck it down. Parliament was, determined to bring about this law, and so everything which was identified as a lacuna was addressed, and the law was reenacted, and subsequently the Supreme Court upheld it. Of course, the other important, I think, amendment in the ID Act was introduction of unfair labor practices in 1982, and that came into force in 1984. I think it's good for us to ask the question, what purpose does the amalgamation of 29 labor laws into 4 separate codes, what purpose does it serve? Very often it is said that it is meant for simplification of the law. I doubt whether this is a true attribute of the reason for the bringing together of this process. If you look at the definition clauses in each of the codes and compare it with the definition clauses which existed earlier, and if you look at the litigation in relation to definition clauses, may I take one, the most leading litigation, and the definition clause which conferred jurisdiction under the Industrial Disputes Act. That was the word industry. Scholars are on record to say, if you plot the decisions of the Supreme Court on the word industry on a graph, then you'll get a zigzag curve. There are occasions when the court would say one thing, and another occasion when the court would say the opposite, and that went on for 26 years. So to find the true definition, the true meaning of a definition, that's been the history of it in India. I think this aspect has been completely ignored. Not because new words have been used, but because old words are now put into the company of statutes which are of a different nature. When you look at the meaning of a word with reference to a standalone statute, that meaning has been clarified through prolonged litigation. But that same word will have a different connotation when you bring it in the company of other statutes which you have now merged and created a code. So that's a jurisprudential nightmare. And I cannot imagine what will be the consequence of litigation in this regard. New meanings will arise, and that itself will be a very unsettling feature. The actual process of amendment is not confined to mere amalgamation. It involves change in the existing framework of law, of labor law and of labor rights. And we must remember that the laws that have been merged are laws of post-colonial origin, especially the jurisprudence, especially the acceptance of the ideas. Though all the 3 laws originated before independence, they are actually welcomed by the ruling elite. And so in that sense, there is a post-colonial endorsement of it. And that is because of the type of capitalist development. I repeat, the type of capitalist development, model of capitalist development adopted at that stage. Whereas now when the merger is taking place, it's not the same. It's during the period of neoliberalism. And during the period of neoliberalism, the political thinking behind all these issues is different. And I think that is the fundamental contradiction, while pretending that this is merely an amalgamation of old laws. So in reality, the 4 codes are influenced by a new ideology, And that new ideology can be traced back to two ideas, global ideas, which have had a profound impact on India. The first one is what is referred to as flexible labor. We know that flexible labor originated in the augmented Washington Consensus. And then the other idea was the so-called ease of doing business. There's almost a joke in respect of ease of doing business. And the joke is when the World Bank developed these parameters, they used criteria in order to measure the extent of ease of doing business. And if you look at 10 leading criteria that they use, not one of them refers to labor issues. And yet, when our stalwarts want to go in for labor law reform, is that issue which they point out as being the most important reason. So this is also it's like a historical fallacy. I think that's the gap between being embedded in a feudal order and a feudal mindset and not transiting even to a capitalist framework. And so we must take note of the fact that there is a paradigm shift. And in that paradigm shift, the dominant element is anti-labor and pro-management. And that is the essence of what changes exist now. So we must therefore begin by making an effort to decipher the critical changes introduced by these codes. And especially now I am confined to the first Industrial Relations Code. And so I will focus on that aspect. In order to summarize this, it's impossible to get a comprehensive picture of what it does to industrial relations, because then at every stage we have to compare it with the old law. And so I'm going to proceed in a different manner. And that is, I will look at the critical changes that the Industrial Relations Code has brought about. And a quick listing has produced 12 important items of change. I'll try and deal with each one of them as briefly as I can. The first and most anti-labor exercise has been the attempt to kill collective bargaining. We know that when workers form a trade union, one of the first things they do is to prepare a charter of demand. And if negotiations on charter of demand is denied, that is when there is a breakdown, and very often there is a strike. Employers may resort to lockout. But when there is a negotiated settlement, then there is industrial peace. And that model has been followed in a good part of the developed world. It is for that reason that there is reference to the period of the golden age of capitalism. And that's a period during which the purchasing power of the workers improve because they've got better wages, and therefore there's more demand. And when there's more demand, there's better production, higher production. And in that sense, there are a lot of positive processes associated with collective bargaining. And even in India, the best of managements have signed multiple settlements with the trade union. I come from the city of Bangalore, and I must say that you identify the best industries, whether it's public sector or private sector, all of them have got into a number of long-term settlements, and they have prospered. Their profits have increased. They have paid higher bonus. Of course, they have improved the wages. And so it's a good package that evolves. It is this which is now sought to be killed. Let me tell you how it is planned to be killed. And that is because, they have now made it almost impossible to have a legal strike. I don't know if I'm unnecessarily qualifying this statement. I'm even, glad to say it is impossible to have a legal strike in India if this law is brought into force. Why does that happen? That happens because earlier we had a distinction in the Industrial Disputes Act between public utility and non-public utility. And if it was a public utility, then a strike notice was compulsory. But if it was a non-public utility, there was no strike notice which was compulsory. Many people may not know this. And moreover, interestingly, many trade unions, even though they knew that no compulsory notice was required, would still give a notice in a non-public utility, because that would prolong the process of exploring a settlement. That would open up last-minute negotiation. And so that was the scenario. Now, what the law says is, whether you are public utility or non-public utility, a strike notice is compulsory. And if you go on a strike without a strike notice, it's illegal. If you give a strike notice, then within 5 days, conciliation must begin. Once conciliation begins, then a strike is illegal. That was again not the position under the old law. And supposing conciliation fails, then any party can take it to adjudication. You don't even have to wait for a reference under the new law. And if that happens, again, the strike is illegal. So if you put all these three things together, in a nutshell, we can say it is now impossible to have a legal strike in India if this law comes into being. I think that is inviting a death knell of proper industrial relations. What's the consequence if this happens? Then it goes on to the next stage, and that is that the registrar of trade unions can now deregister the trade union. That kind of a power the trade union registrar never had in the past, because the trade union registrar never got into a dispute concerning industrial relations, because that was governed by a separate law. Now that the three laws have been brought together, the trade union registrar comes into the picture, because if there's a violation of the statute, for the future, the statute is the IR code. And so going on an illegal strike is violation. And therefore, the registrar is now newly empowered in order to intervene, and he can proceed to deregister the trade union. Those of you who are interested must take a peep at section 9(5) of the IR code to get into the details of this. Apart from that, there's an interference with the internal democracy of trade unions. There has been a very good tradition in labor jurisprudence, and that is so far as the way in which trade unions are organized, how they run their affairs, how they elect people, how they manage all their processes, is a completely internal matter of the trade union. Nobody has a right to interfere in that. What the new law says is how much a membership fee should be collected may be determined as prescribed. This is an unnecessary interference into the affairs of the internal democracy. Then you also have, an old provision in the Trade Union Act, and that is, apart from the general funds of the trade union could collect political funds. There was only one condition, that if you collected political funds, it should be known that you are doing so, and that fund can be used only for political purposes. And what are political purposes? It may include anything connected with the election of a member of the legislature. Maybe in our case, for electing an MLA or for electing a member of parliament, funds could be drawn from the trade union through the political fund and used for this purpose. That was written into the Trade Union Act of 1926. This provision has suddenly disappeared. Of course, that's an interesting omission. It's not an accidental omission. You can see where this trend of thinking comes from. Then there is also the desire to upgrade privatization of dispute settlement machinery. I just want to mention in that regard that arbitration was not a part of the original mechanism. It did get into the ID Act for various historical reasons, connected especially with the Textile Labor Association of Ahmedabad during the period of Gandhiji, and gradually arbitration was upgraded as an equally useful method of dispute resolution. Now, with the first thing that I mentioned, namely collective bargaining is getting downgraded, industrial adjudication is taking on a new feature, and combined with that, if you get into arbitration and encourage arbitration, the new code sets apart a chapter for arbitration. And not that it adequately covers all the problems, because there is no reference to an empire. If arbitration is to consist of representatives of trade union and employers, and if there's a difference between them, how is that difference going to be resolved? Well, maybe that lacuna will be identified and cured. But in any case, arbitration is like the privatization of dispute settlement. And I think that is a very sad development, which is appears to have attracted a lot of priority under the new law. Then there is, the desire to spread the occurrence of non-performing assets in industry. I would look at it that way. I say so because very long ago, the Reserve Bank of India produced a report about sickness in industry. And they said sickness in India is a profitable business. We all know that. We know that the extent of non-performing assets which accumulated in India was 11 lakh crores. And instead of recovering that, the Insolvency and Bankruptcy Code is writing them off left, right, and center. They call it a haircut. It's actually the workers whose hairs are being shaved, if I might use that expression, because it is public money. And under the old Chapter 5B, read with the Sikh Industries Companies Act and the Board for Industrial and Financial Reconstruction, it was possible to look at what is the cause of sickness. Is it a bona fide sickness? If it is mala fide, what should be done? And then the assets would not be completely dumped. And that, I think, is now sought to be relegated by virtue of the fact that Chapter 5B will no longer apply as in the past. The preliminary precondition is there must be 300 workers if this chapter is to be attracted. There's also, the sanctification of the process of hire and fire. And that is done by upgrading the expression fixed term employment. Of course, there were tendencies in this regard, even in relation to through interpretation of the ID Act. Now it is being upgraded, and fixed term employment can now become part of the Industrial Employment Standing Orders Act. And ironically, the same Occupational Safety Code says in future, every worker will get an appointment order. I'm fond of saying that along with this appointment order, he also gets on the same day his termination order, because they're telling him in advance when your services will end. So that dimension, the standing committee had very interesting observations to make in this regard, but they were just put into the waste paper basket. It's only recorded, but no consequences have come from that. Then, in relation to the definition of industry, on the one hand, one is happy to note that the triple test invented by the Supreme Court of India has been put into statutory form. But on the other hand, it has been denuded of its full import. And that is, if it's a charitable institution, if it's a philanthropic institution, then, those establishments run by such organizations may not come under the definition of industry. And even sovereign activity is exempted. The case law in respect of industry has shown that over a period of time, how municipalities were covered by the term industry, how hospitals were covered. And so this attempt to exempt new categories, it leaves employees in those sectors without any remedy. The only remedy they will have is civil remedy, which means that you go back to the law of contract. And so I think Kavya made a reference to this phenomenon as a growing phenomenon, and that is encouraged through the changes that we are now referring to. However, I must say there is one good provision, and I am happy to mention that good provision upfront in a proper manner. And that good provision is, in India, there was no central legislation. I repeat, central legislation on the question of recognition of trade unions. In the public sector, many trade unions, we managed to negotiate with the management and enter into 12-3 settlements in which the process of recognition was agreed to and implemented for many, many years. In Bangalore, I can verify that this happened in HMT, in HAL, in Bharat Electronics, in Bharat Heavy Electricals, in Bharat Earth Movers, 5 big public sector undertakings of Bangalore. Everywhere we followed the method of recognition of trade union, and that too by using secret ballot. Whereas for a long time, there was no legislation. There's a political history behind it. I must say that when Babu Jagjeevan Ram was the Labor Minister of India, that's in 1947, he introduced an amendment to the Trade Union Act in order to say that recognition must be incorporated into the law. But the political leadership at that time, which was Nehru, they didn't want recognition to be given. And I think that is partly because of the fear that if recognition is brought into the law, then the left trade unions may dominate the scene. So as a result, the Trade Union Act was never amended. Just now, this law seeks to amend it and introduces recognition of trade unions. I welcome that part of the law with one caveat, and I'll mention the caveat shortly. But first of all, let me say, what is the mechanism of recognition of trade union? They've now conceived of 2 institutions. One is creating a negotiating union, which is also called as the sole negotiating union. And the other is creating a negotiating council. If there's only one union in an establishment, the employer shall recognize such a trade union as a sole negotiating union. That's a breakthrough. And I'll tell you something more related to this before I move from this point of view, and that is, this is a benefit which even the unorganized sector can take in a manner in which it was not available to us before. The second option is, if there are more than one trade union, then any trade union which has 51% of support among the workers, that union will be recognized as the sole negotiating union. That's a welcome democratic principle. It must be welcomed. We have all pleaded for it in the past, and now it is there in the law. If there is no trade union which gets more than 51%, multiplicity of trade unions, and nobody has a simple majority, then the unions which have not less than 20%, they will all be brought together, and each one will be given one representative for each 20%. And they will be constituted into a negotiating council. And the employer is tasked to constitute such a negotiating council. You can expect problems because not everybody, unless they become suddenly enlightened, is going to abide by this law. And that itself would require, I'm sure, public action. And if recognition of this variety happens, it is a great move in the right direction. And I must say that this is so because of another reason, and that is also part of the Industrial Relations Code. If you look at the definition of worker in the Industrial Relations Code, then the definition finally incorporates the unorganized sector in a very useful manner. And so I think we must welcome this positive change. What the law says is, so far as Chapter 3 of the Industrial Relations Code is concerned, Chapter 3 is the chapter which deals with trade unions. And so far as that chapter is concerned, the definition of the worker will be understood as being wider in nature. And what's the meaning of saying wider in nature? Wider in nature means that it will be as if the definition of Unorganized Workers Social Security Act, Section 2M, will now become applicable for the Industrial Relations Code. This is a provision which must not be missed and likely to be mixed because it's the tail end of the definition of worker. What's the consequence of this? Consequence is a home-based worker can unionize. A self-employed person can unionize. You may not be a wage worker, or you may be a wage worker in the unorganized sector. You may be temporary, you may be casual, you may be migrant, you may be domestic. You may be a domestic worker and still you can form a trade union. And any worker in the organized sector who doesn't get the classical coverage of other favorable laws like the Workmen's Compensation Act, the ID Act, the Employees Provident Fund Act, the ESI Act, the Gratuity Act, the Maternity Benefit Act, they will also be treated as workers for the purpose of trade union building. So this is a welcome feature. If that feature is coupled with compulsory recognition, I would submit that it's a tremendous breakthrough. And so we must look at that as perhaps the most important, achievement so it's actually, I must say it's a product of a long period of struggle of the workers. And I think I take the liberty of saying that this would have happened because the Bharatiya Mazdoor Sangh, which is a part of the ruling party, they were also part of the agitation in the old days against the phenomenon of not readily recognizing trade unions. So perhaps that legacy has now converted itself into a positive aspect, and I think we must take note of that. The last thing that I shall mention in this context before I wind up is that approaching the industrial tribunal has now, through the mechanism of a direct application, not through the mechanism of a reference. It will require some further thinking, but I have a feeling that when it comes to questions relating to the burden of proof, when there was a reference, then the reference would put the burden of proof in relation to litigation almost entirely and always on the employer. But now if you say that you can approach the industrial tribunal just as you approach a civil court, then the jurisprudence in relation to burden of proof may also shift, and that's not an advantage. So those are the important far-reaching changes. As I mentioned, this is not exhaustive, but I think that's the most important negative features of the industrial relations code. And the most important positive feature I've already mentioned. So with that, I end my presentation and hand over to Kavya.
Thank you so much, Professor Babu. That was a very comprehensive and yet very focused discussion on changes in Indian labor law with respect to international relations. It was really interesting to listen to everything that you had to say, especially these 12 items of change in the Indian law on and how they are likely to affect collective bargaining, how they're likely to make it difficult for workers to go on strike, affect the internal democracy of trade unions and the financial autonomy, as well as other parallel concurrent movements with the privatization of dispute settlement, the legalization of fixed-term employment, which is likely to further individualize the employment relationship and make it even more difficult for workers to participate in industrial relations without the fear of being terminated or without the fear of their contracts not being renewed once again after their expiry. Thank you also for acknowledging a couple of good and important additions to the labor law, such as, like you said, the recognition of trade union at the industrial level and the acknowledgement that that unionization can occur not only in the stereotypical image of the law, which is industrial workers working in factories, but also among various categories of informal workers. I'll open the floor now for questions. I think we already have one question from Chirayu, and I can see another by Rajesh and Lissy. So I'll just give you the questions. I think all of the questions that we have now, and we'll maybe if after you answer those, we can come back to the next round of questions. Chirayu asked a question earlier about something that you said about the amalgamation of 3 labor laws into one and how that's likely to have a jurisprudential impact on the interpretation of different definitions. He was asking if there is any definition in particular that you think is likely to be affected by this amalgamation, if you can predict where you can foresee that kind of trouble occurring. Lizzie Joseph is asking what part of the Industrial Relations Code has applications on unorganized workers. And Rajesh is asking about while arbitration was already a part of labor law before, why is there then this concern about the privatization of disputes?
Shall I begin with those 3?
Yes, please.
Now you inform this thing. Or you will get that offer letter.
Sorry, I'm missing what's happening.
Sorry, I think someone was unmuted. Please go ahead, yeah.
Yeah, Chirayu, I think the example I was quoting about the new power which the registrar of trade union gets in order to deregister a trade union. What's the nature of the new power? The new power is in respect of an illegal strike. Imagine the Trade Union Act in its old form. The Trade Union Act never dealt with the question of illegality or legality of strikes. And therefore, he did not have the power to do something which was a subject matter of a dispute in the Industrial Disputes Act. But now that's not the situation. Now, he is in the same framework of the Industrial Relations Code. And so when you're talking of illegality, illegality covers matters which are connected with industrial relations by virtue of the fact that it is the same code. Earlier also, to clarify, the registrar had such a power, but that power would be with reference to violations under the Trade Union Act. For example, non-compliance with filing of returns, non-compliance with the provisions of the Trade Union Act. He could invoke deregistration. Now he has the power to invoke deregistration in respect of an illegal strike. I think that is one example that is a far-reaching consequence. So far as the other question, I think that is from Lizzie Joseph. Yeah, you know, as I was mentioning at some length, the most important change for the unorganized labor in a positive sense is the consequence of you know, the wider definition of worker, as a result of which now somebody who's not even wage labor can form a trade union. And not only form a trade union, when you refer to Chapter 3 of the Industrial Relations Code, you can also seek recognition of that trade union, and recognition involving either sole negotiating union status or the wider negotiating council status. As for the third, Rajesh's question, yes, it is true. In a way, what you say is an important dimension. I am comparing it with the downgrading of collective bargaining. And when you downgrade collective bargaining and you modify adjudication in a manner in which you now become an applicant before the tribunal in a manner which is very similar to going before a civil court, then the jurisdictional issues, especially burden of proof. You know, to give an example, when we got a reference from the government in respect of a worker dispute, the question that would be posed in the reference would be, is the management justified in terminating the services of such and such a worker? Now, if there's no reference, you don't have that kind of language. It's maybe the worker who has to go to the court, to the tribunal, and he will have to make a submission, I have been illegally terminated. So immediately the court will shift the burden of proof. You prove that you are illegally terminated. That's one example I can think of where adjudication is downgraded. Collective bargaining, I've already explained, is downgraded because the moment you go on strike, there is no effective collective bargaining unless the threat of strike is also legally available. You may or may not resort to strike. But now an employer knows that nobody can go on a legal strike, and therefore collective bargaining is also downgraded. Then what is it that remains? In conciliation, you may or may not arrive at a settlement. If you don't arrive at a settlement, you're back to the adjudication route. So in other words, all these three institutions are downgraded. While they are downgraded, arbitration remains on all fours, except for some of the defects which I already pointed out. And so that's where I think, it is pushing in the direction of privatization of dispute settlement.
Thank you, Professor Babu. I think Rajesh has a follow-up question to that on needing more clarity on the recognition of trade unions in the unorganized sector, because the condition of being representative of 20% or 51% in the unorganized sector especially is so difficult to fulfill. But there's also two more questions, so I'll pose those to you and then hand over.
Yeah.
Arju John has a question about the implications of the IR code for the protection of unions or independent activists from civil and criminal liability for industrial action. And Isha Kunduri has a question regarding the unionization of unorganized workers.
Sorry, I didn't get the last observation about criminal.
Arjujan was asking what the implications of the Industrial Relations Code are on the protection of unions or independent activists from civil and criminal liability for industrial action.
Okay.
I'm interested to know what you say about that. Also, because I remember you mentioning earlier how the Industrial Disputes Act was enacted so the Trade Unions Act was enacted in response to a case of such liability being cast against one union organizer in the Buckingham Mills.
Yes. So if I might begin with that, there is no difference in the legal position so far as the Industrial Relations Code is concerned. When you look at Chapter 3 dealing with trade unions, the same kinds of immunity which were explicitly provided in the Trade Union Act of 1926 are repeated in the current law also. So on that score, there is no new disadvantage. I was mentioning it more by way of tracing the history of the Trade Union Act. What's the one?
Thank you, Professor Babu. There's two more questions about the unionization of unorganized workers. So I'll just put those together for you. Isha was asking about how agitations and resistance efforts have always been involved for the unionization of unorganized workers, and SEWA particularly comes to her mind. So she's asking what the implications are for such independent unions who have historically worked to organize unorganized workers. Are there any protections for them under the new codes? Rajesh's question is on the recognition of trade unions and how that might be more difficult in the unorganized sector, given that it's very difficult for a union to be representative of 20% or 51% of the workforce at the enterprise level. Isha has a follow-up question on, again, negotiation. She's asking about the clause on the sole negotiating union. She's wondering what the implications are in case there are multiple unions with multiple contested agendas, and how you think that might play out under the new law.
Yeah, I begin with the more difficult question posed by Rajesh. Yes, recognition always has that difficulty. Supposing you seek recognition of the engineering sector of the organized workers, you will face the same problem. How wide is this engineering sector? And therefore, how would you ever sort it out? But if you are able to narrow it down to a particular unit, let us take the BD industry and say, Ganesh BD factory in Mangalore, then you know whom you are referring to. So if you're looking at industry-wise wide recognition, I agree, that is more difficult. Let's take the Bank Employees Federation. At that level, because they are highly organized across the entire sector, it can happen. So maybe on some future date, if federations of unorganized worker unions are, if they come into existence, then perhaps it is easy. Otherwise, it's the same problem, whether it is organized sector or unorganized sector. How will you determine which unit you are seeking recognition for? And that will depend upon what kind of a trade union you form. That decision is left to the trade union people. You might decide to form, 10 separate units of unorganized workers. On some basis, it may be geographical if that is convenient, or it may be some other criterion. And then you can federate it later on for, reasons of getting strength. But, it's easy to say all this. That's a tougher task. And I recognize, I think that we'll have to think over in more substantial way. As for the sole negotiating union, yes, I didn't mention everything. The issues on which a sole negotiating trade union can negotiate will be as prescribed. So generally, the trend in the past has been collective industrial relations or collective disputes are subject matters that are considered to be proper for negotiation. But even during the era of recognition, when there are multiple trade unions, there can be an understanding that in respect of, let's say, individual grievances, if a worker belongs to one of the unrecognized trade unions, can that unrecognized trade union espouse the cause? I think those aspects are not yet clarified in the present law.
Thank you, Professor Babu. I think we can take a couple more questions. I see Pranita and Aju have asked questions, and Sucharita has raised her hand. So I'll just pose Pranit's and Aju's questions. And I think once you answer those, maybe we could hand over to Sucharita, because I think she has a couple of questions herself.
Yeah, I posted my questions on the chat. You can see it there. I've posted my questions on the chat.
Sure. Okay.
To you. Yeah.
Sucharita has asked 3 questions. One is the implication of the changes in the Industrial Relations Code for gig workers specifically. The second is she's wondering if you could comment on how the 2 oldest postal workers unions have recently been de-recognized. And a third question is about Air India, which was recently privatized and taken over by the Tata Group. And the Tata Group has recently refused to recognize the 2 unions of pilots. So she's asking if this is connected to the new code and how you might interpret those.
No, I think disputes relating to recognition of trade unions and what I have said will not be correlated because the new law has not come into force. However, there is old case law on matters pertinent to recognition. And so that's a route which perhaps is still open, maybe open through the Industrial Disputes, Old Industrial Disputes Act route. And there are, I think it is in the case of Madras High Court that there are some good rulings about how to handle recognition disputes. And they have fallen back largely on some of the recommendations of the Indian Labour Conference of the past. And on that basis, they have suggested that those guidelines should be used for recognition. But that is the old law. And since the new law is not yet into force, it is the old law that would be pertinent and relevant. But in each of those cases, it would require a competent lawyer to address those issues, because the facts in those cases I'm not familiar with. As for the gig workers, no, this code doesn't handle questions of the gig workers because it's the Social Security Code that is looking at the issues of the gig workers. And so the attempt to say that the gig worker is not a worker is that's an attempt made in the Social Security Code by introducing the idea that they are people who do not have an employer-employee relationship. So that's an attempt to bypass the eligibility of gig and platform workers as workers. But that definition, we can argue that is statutorily confined to the Social Security Code. Why should that be brought into the jurisdiction of the Industrial Relations Code? So I would tentatively say that a gig worker is entitled to raise a dispute. In fact, in Bangalore, we have been advising friends who have been terminated to raise a dispute. And I'm happy to say that the Labor Department has sent it to the government for reference, and the government has sent it to the Labor Court for adjudication. I am sure that one of the points that will be taken up in the adjudication is an argument by the employers to say he's a partner and not a worker. And so that will be subject matter of dispute. And in that dispute, we are familiar with international jurisprudence moving more and more in favor of the gig and platform workers. The best example is the Supreme Court judgment in England, where 7 judges have unanimously held that gig and platform workers are workers. But that is under British law, and that does not mean that all its implications will be applicable in the Indian court. But slowly, international jurisprudence, including in the European Union, is moving in favor of the gig and platform workers. We have drafted a bill in the National Law School for gig and platform workers, but that's a separate subject matter in itself.
Thank you, Professor Babu. You really nicely explained what I wanted to know.
Thank you.
Thank you so much.
Thank you, Professor Babu. There's 3 final questions, and I'll ask you those together on 3 slightly different things that came up today in your talk. Praneeth wants to know how, as per the IR code, the tribunal will have a bench consisting of a judicial member as a presiding officer and an administrative member. And he's wondering if you think it will have any impact on adjudication in the tribunal. Aju has asked a very interesting and very important questions. I know some of your thoughts on this. He's asking whether the IR code, by hollowing out the collective bargaining process, whether it forecloses the potential of collective bargaining agreements that rise above the statutory minimums. And Sophie, I think this is Professor Sophie, is asking, is suggesting that it might be good to elaborate on the rules of recognition. She's asking, isn't verification through secret ballot by verification officer appointed by the employer going back from an impartial process derived through jurisprudence?
Yeah, I didn't know Sophie was. Actually, Sophie is more competent to answer this subject, this issue herself. We worked together, and when we were working together to formulate rules for the Chhattisgarh government, it was Sophie who was in charge of this question, and I know she has done thinking and work on it. Now, I'll just share my view. In the relevant portion of the section, there is the language of verification. And we know historically that so far as recognition is concerned, there have been 3 methods followed in India. One is the method of secret ballot, the other is the method of verification, and the third is the method of check-off. However, when they use the word verification, I'm inclined to say, let us not give it its narrow meaning of verification as we understood in the past when there was no statute. After all, the word verification is not defined for that purpose under the Industrial Relations Code. So I would interpret it to say how to verify is left to delegated legislation. And therefore, Kerala and Tamil Nadu have already said that they will do the verification through the secret ballot method. And I think it's the wording of Tamil Nadu government which is the most creative in this regard. So they've used the word verify in order to say, yes, we will verify, and for the purpose of verification, we'll use the method of recognition. I mean, secret ballot. So that may be one way of interpreting it. But I would encourage, Sophie to share with all of us what may be some other point of view on this subject matter. Now, before that, I'll finish the other part also about tribunal. Yeah, as it is, we are all familiar with the endless delay in adjudication when there is only one member who is the presiding officer of a tribunal. Now, if you bring in two guys, one from the judiciary and one from administration, the scope for prolonging this adjudication will become even more. Plus, if there is a tie between the two, if they differ between the two, then the solution appears to be that you must import another judicial member from a neighboring tribunal in order that you can ascertain what's the majority view. So all that is going to make matters much more, the delay in all legal fora will be prolonged by this process. Where is the need for a multi-member tribunal? What you require is a competent presiding officer of a tribunal instead of importing somebody from civil jurisprudence or criminal jurisprudence. As Justice, I think D.A. Desai had recommended in the Law Commission, produce a group of people who have the specialization in labor law, then those matters can proceed faster. Over to Kavya, and if Sophie is still online and inclined, I think we must hear her view on this matter.
Hello, good evening, sir. Good evening, Kavya.
Good evening.
Hi, good evening, everyone. From the reading of the rules, what we understand as verification officer is appointed by the employer, and the verification officer prepares the voters list after doing the verification process, and based on the voters list, there is a secret ballot. So my understanding is, as you refer to the case law, MRF case law by the Madras High Court, and also the Food Corporation of India case of 1995 by the Supreme Court. In all of these cases, it's very clear that one is the Supreme Court also saying the verification process has become obsolete because of the criticism against it. And over a period from the successful rate of wage settlements by the trade unions and public establishments, the trade unions which got recognized through secret ballot. In MRF case, the court is also recognizing that as a timely method to do a secret recognition process. So in both the cases, the court is basically saying, while the presiding officer is from the management appointed by the employer, the returning officer need to be from the labor office. So labor officer need to be the returning officer. So here the verification officer appointed by the employer is handling the entire process from the reading of the rules. So isn't there a third-party supervision, a kind of transparent process there? Because the complete process is in the hands of the management here. So it becomes a management-driven process. So that's why I asked about this question of impartiality or non-interventionism actually considered as the best practice according to the ID Act as well.
Yeah, thank you, Sophie. I think this is an aspect which will require deeper examination. I think perhaps what you're saying becomes a little more applicable. I'm not saying it's not applicable in the other situation. I'm saying it may be more applicable in the context of creating a negotiating council because the language pertaining to that part in the statute appears to place a heavier responsibility on the employer. And so maybe they will be further empowered in that regard. And that's where more mischief can be played also. And that is where we must resist the old method of verification. I don't know whether the language in Tamil Nadu and Kerala are very different in this regard, and whether we can explore the possibility of challenging delegated legislation as seeking to maintain a pre-statutory era of dealing with recognition. But those are all questions for the future, the litigative part, I think. But what
In
is
fact,
first?
there is a,
Yeah,
sorry.
go ahead.
In fact, there is a petition filed before the Madras High Court by Southern Railways Management Union against this draft rules. So, no, I read it in a news articles. SRMU has filed a petition against 14.3 and 14.4, and also the rules, vis-a-vis the rules of the draft rules. Yeah.
But will not the court say that when the statute itself is not in force, how can you come and challenge the rule?
That's the question, I think, but the court has asked the state to file an affidavit or something.
Okay.
That's what the news article says. So.
Okay, okay. Anyway, I'm glad the litigation is coming up in Tamil Nadu, because that seems to be the place where there is the chance of the government taking a more pro-worker point of view.
Yes.
I would say that this was unfortunately we need to stop the discussion because of our time limits. But it had a really good discussion on the IR code, and this is just one. This is our first session on IR code, and we are going to have a lecture series on all the other 3 codes every Friday at 5 p.m. In this month of May. And the next lecture will be on next Friday, which is on 12th May at 5 p.m. same time. That lecture on wage code, and that lecture will be, that session will be done by Advocate Gayatri Singh. And Gayatri ji, Babu sir had helped a lot to organize this labor code lecture series. So I would not only thank Babu sir for doing this session, but also to help us organizing this whole lecture series, and to have a discussion on labor codes, which is kind of a very mystifying word for all the activists and labor activists and researchers who are working on at grassroots level. And I would also like to thank Kavya for our last minute invite to moderate this session, and she had accepted it even if there was a time difference between UK and India. And I would also like to thank all the participants who have joined us and had given a lot of interesting questions to take this discussion ahead. And I will request everybody to please be in tune with other sessions as well, and help us to make this discussion more interesting in other sessions. Thank you so much.
Thank you. Thank you very much.
Thank you so much, Chinmay.
Thank you, sir.
Thank you.